Good morning, everyone, and welcome to our third and final week of this 2023 Department of Education negotiated rulemaking. My name is Brady Roberts with Federal Mediation Conciliation Service. We, as always, have a very packed agenda today, so I'll get right into a roll call and then I'll move to old business. So kicking us off, joining us on behalf of civil rights organizations, we are joined by Wisdom Cole.
Here.
Morning. And his alternate, India Hextall.
Here.
Representing legal assistance organizations that represent students or borrowers, we are joined by Kira Taylor.
Good morning.
Good morning. And her alternate, Scott Waterman.
Good morning.
Representing state officials, including state higher ed executive officers, state authorizing agencies, and state regulators of institutions of higher education. Lane Thomas, the primary, will not be joining us today, but we are joined by his alternate, Amber Gallup. Do we have Amber? I'll be sure to note her when she's able to join us. Representing state attorneys general, we are joined by Yael Shavit. Oh, I see you. Good morning, Yael. You're on mute, but good morning. And we're joined by her alternate, Josh Devine.
Good morning.
Morning, Josh. Representing public institutions of higher education, including 2- and 4-year institutions, we are joined by Melissa Coons.
Here.
Morning. And joined by her alternate, JD LaRock. I think we're still missing JD, but I'll note him once he is able to join us. Representing private nonprofit institutions of higher education, we are joined by Angelica Williams.
Good morning. Here.
Good morning. And her alternate, Susan Tierink.
Good morning.
Good morning. Representing proprietary institutions, we are joined by Kathleen Dwyer.
Here.
Morning. And her alternate, Beline Gonzalez.
Morning.
Good morning. Representing historically Black colleges and universities, tribal colleges and universities, and minority serving institutions, we are joined by Sandra Boehm,
Here.
And her alternate, Carol Peterson. I thought I saw Carol join, but I'll note her once she's able to join us. Representing federal family education loan lenders, servicers, or guarantee agencies, we are joined by Scott Buchanan.
Good morning.
Good morning, Scott. And his alternate, Benjamin Lee.
Morning.
Morning. Representing student loan borrowers who attended programs of 2 years or less, we are joined by Ashley Pizzuti.
Here.
Morning. And her alternate, David Ramirez. Again, I don't see him, but I'll note him when he's able to join us. Representing student loan borrowers who attended 4-year programs, we are joined by Sherry Gamage.
Here, good morning.
Good morning, Sherry. And her alternate, Sarah Krista Butts.
Present.
Morning. Representing student loan borrowers who attended graduate programs, we are joined by Richard Haas.
Morning.
Morning, Richard. And his alternate, Dr. Jaleel Bishop.
Here.
Morning. Representing currently enrolled post-secondary education students, I believe Jada Sanford, the primary, will be joining us later. So we are joined by her alternate, Jordan Nellums.
Good morning.
Good morning. Representing U.S. military service members, veterans, or groups representing them, we are joined by Vincent Andrews.
Yes, present.
Morning. Representing individuals with disabilities or groups representing them, we are joined by John Whitelaw.
Good morning, colleagues.
Morning, John. And his alternate, Lakeisha Wilkerson.
Good morning.
Morning. Last but not least of our non-federal negotiators, we are joined by, representing consumer advocates, we are joined by Jessica Ranucci.
Good morning.
Morning, Jessica. And her alternate, Ed Bolts.
Good morning.
We are, of course, joined by our federal negotiator, Tammy Abernathy.
Good morning.
Morning, Tammy. And representing the office, the department's Office of General Counsel, I believe we are represented this morning by Mr. Soren Lagarde.
Good morning.
Morning, Soren. Did I forget anyone? Apologies if I did. I know we had some folks join a little bit late, and I want to make sure we let folks know that you've joined us. Okay, with that, I want to move right into revisiting some old business, specifically adding a new constituency group. Just a quick process check. You should have received an email on Friday. Did everyone receive that email noting that new constituency group?
Brady,
Yeah.
could I make a couple of announcements and handle the other old business before we jump into a new constituency group,
Oh, of
please?
course, yeah, please.
Thank you. Thanks so much. Welcome back, negotiators. We are now in the third session of our negotiated rulemaking on student loan debt relief, which specifies the Secretary's waiver authority under Section 432A of the Higher Education Act of 1965 as amended. On December 4th, we sent the agenda and proposed regulatory text to you. We have also publicly posted all related materials on our official website. We look forward to our discussion and to moving toward final consensus on the areas covered in the proposed text that was sent to you or over the next 2 days. In addition, after final consensus, we've set time aside to discuss hardship. As a reminder, we have a good deal of work to get through, so we'll start with the old business as Brady mentioned, and then we'll focus our attention on reviewing the proposed regulatory text. There are a few updates. I wanted to make mention that all of the responses to questions from session 2 have been provided verbally to the negotiators, and the data requests were filled and provided to the negotiators in advance of this meeting, and there are no outstanding data requests. Seeing as this is the final session, we are unable to fulfill any additional data requests. We appreciate the regulatory text proposals many of you submitted, and we will touch on them as we navigate through the agenda today and tomorrow. Thank you, Brady. I'll turn it back to you.
Of course. I do just want to note, I believe that Amber Gallup, representing state officials, has joined us. So I just want to say good morning to Amber. Morning, Amber. Sarah, I see your hand. Oh, I believe you're still muted. I apologize.
I just wanted to mention in regards to data requests that we did make a request for any public service professionals that qualified for PSLF forgiveness, but still have remaining loans. And we understand that the department's unable to give us that information.
Okay, thank you, Sarah. Yael, noting your comment, welcome to the table, Josh, on behalf of state AGs. Quick process check. Did everyone receive Josh's proposal on a new constituency group? I believe it was sent last Friday. Not seeing anyone note that they didn't get it. Josh, anything to add to the group for discussion? Otherwise, happy to move to a consensus check.
Yeah, I'll just give a little bit of a brief introduction.
Yeah.
As I mentioned during the November session, several different communities of interest have reached out to me to express their concern. They say that a critical interest group was never invited to the table. This all stems, I believe, from oral arguments earlier this year in the initial student loan process, where the Chief Justice and Justice Alito asked questions about the fairness of the department's previous student loan program. Namely, this is a very, very large, that program was a very, very large, very expensive program given to students, but not necessarily, there's essentially no program for small business owners, people who didn't go to college, people who went to trade schools or took out or went to an alternative or went through alternative career processes. The Supreme Court gave the example of a small business owner, a landscaper, things of that nature. And so in November, the department said, if a committee were to add a new constituency group, somebody would need to propose negotiators. So that's what I'm doing today. So this is a constituency group that would represent individuals who are taxpayers, representing the community of interest that does not hold student loans. One of the individuals in the document I circulated last week, one of the individuals had a conflict arise over the weekend, so I'll just discuss the other two. First is Betsy Miller. I nominate her to be the primary negotiator. Ms. Miller is a Missourian and the founder of a successful professional organizing firm called To Be Organized. Her firm specializes in organizational architecture. She helps clients move, sell their homes, downsize, event plan, things of that nature. Started in 1997, her company now has 15 locations across the country. She is also very heavily involved in community philanthropy, including helping rebuild Joplin, Missouri after the devastating 2011 tornado. As the alternate, I nominate Alex Williams. I mentioned last week that Missouri differs substantially from Massachusetts in that Massachusetts is the state with the highest percentage of adults who have college degrees, whereas 70% of Missouri adults do not have a bachelor's degree. There's one other big difference, which is that Missouri is home to College of the Ozarks, which has an innovative financing model. Nicknamed Hardwork University, the college has a zero tuition model where students, instead of paying tuition, work in on-campus employment jobs. And that's how Alex Williams was able to obtain his bachelor's degree. Since then, he founded a successful flooring business in Branson, Missouri. He's also very active in the Branson community, including as a member of the city's finance committee. He's also a combat veteran. I'll leave the rest for the committee.
Great, thank you, Josh. Tammy, you have your hand up.
Thank you, Brady. Thank you, Josh. The department would be interested in hearing opinions from other negotiators if they're willing to add this constituency or not. The department has concerns about adding a constituency group this late in the process. And we do note that this constituency group is not among those contemplated in the requirement for negotiated rulemaking in the Higher Education Act. But we would like to hear thoughts from other negotiators. Brady?
Thank you, Tammy. Would any other negotiators like to add to the discussion? Yeah, Ashley, please.
I just want to point out that I actually fill quite a bit of those spaces. I am a small business owner. I am a taxpayer. I went to a trade school, and I actually no longer have any student loans. So I fill a lot of those roles. They're already having a seat at the table.
Thank you, Ashley. Anyone else? Yeah, Kira.
Thanks, Brady. I would also like to note that this is awfully late in the game to add a constituency group, given that we've already had 2 rulemaking sessions where we had robust discussion of all of the proposals on the table. I wonder why this constituency group is being added this late in the game. In addition, I'm curious as to what the student loan expertise of these proposed individuals are, given that these programs are incredibly complex. The Higher Education Act is incredibly complex. And I did not see any evidence of those individuals' experience or familiarity with the Higher Education Act or student loans in the bios that were provided.
Thank you, Kira. So we will take a consensus check on this. Just as a reminder, per the ground rules we've agreed to, all primary constituency groups are going to get a vote. So if you're a primary negotiator, feel free to turn your camera on. As a quick reminder, we're going to ask for a show of thumbs. To add a new constituency group, it needs to be a unanimous consensus vote. So a thumbs up indicates a yes vote. A sideways thumb does not indicate a yes or a no, but you're not withholding consensus. So if it is all sideways thumbs, for instance, you would still technically have consensus. And then a thumbs down would represent an individual or a constituency group has serious concerns with voting in the affirmative for a consensus check. Any questions about that? Okay, so at this point, I'm going to ask all folks with their camera on who are voting members to please indicate their consensus vote towards adding a constituency group per Josh's proposal. Okay, I do see several thumbs down. So we are not in consensus on adding a new constituency group, but Josh, I do see your hand up, please.
Yes, well, I appreciate the committee taking the time to consider this today. As I said, you know, I have had a lot of people who expressed serious concerns to me about this issue over the past several weeks. And because the committee has decided not to go along with adding this constituency group, I'm going to go ahead and withdraw at this time from my own participation in this committee. And I will submit something formal in writing to the facilitators. Again, thank you for taking the time this morning.
Thank you, Josh. Jessica.
Thanks. I think that changes a little bit what I was going to say, which is that, you know, I think that Josh has provided a voice for his constituents in Missouri. And I would also just like to note that whatever rule comes out of this negotiated rulemaking session will be subject to public comment. And so I think that this is not by any means the last opportunity for the public to weigh in. And I think that I agree with the negotiators who said that sort of at this stage, I think we're dealing with some technical student loan issues. It's really late in the game, but that I think that I think that there is like a whole nother public comment period that's going to happen for, you know, after the proposed rule comes out that would be appropriate for public comment. Thanks.
Great. Thank you, Jessica. The only other old business that I would note, I just want to quickly remind folks of what the goal here today is to do. So you all received a lot of proposed regulatory text from the department. Today, the plan is to have the department share that text, provide a walkthrough of the text, some of the changes that they're proposing. We're going to take temperature checks, which is a phrase that we've been using with some regularity in previous sessions. That is not an official consensus vote. It is really just an opportunity for the department to solicit the group's feedback on their disposition towards the proposed regulatory changes. So it takes the same form. A thumbs up is you have no problems with the regulatory text. You would vote in the affirmative on consensus if this was a consensus check. A sideways thumb, as always, you maybe have some reservations, but you're not withholding consensus. And then a thumbs down, you would withhold consensus. You have serious problems with the regulatory text. What we're going to do with those folks who vote in the negative, who vote with a thumbs down, is ask you to come off of mute and share what your serious reservations with the proposed text in its current form would be, and what changes you might propose to bring it in line with something that you could see yourself at minimum voting sideways, not withholding consensus from. You're going to have the opportunity to submit any changes, minor or technical edits to the regulatory text. We might be able to do live. However, if they're more substantial in nature, we're going to ask you to submit those in writing and put them in the chat and send them to the facilitation team as quickly as possible, just so we have time to disseminate that and for additional discussion to be had. Am I forgetting any old business, Tammy? Otherwise, I'll turn it right back over to the department to kick us off.
Thank you, Brady. No, but you stole some of my thunder in my opening remarks, so I might have to repeat some of that.
That's all right.
Thanks again. Let's take a few minutes to articulate the process and flow for the last session. We'll start by reviewing each section of the amendatory text. I'll turn it over to FMCS for temperature check, and then we'll have discussion, just like Brady said. I would also like to mention that the department may make minor changes to the amendatory text live if needed, but please be patient as the screen sharers update the text accordingly. There might be a little bit of a delay with the screen updating. So if you have substantive regulatory text changes like Brady mentioned, please follow that process.
All right, fantastic. Tammy, on my list first, I have subpart G for discussion. Do you want to?
Actually, what I'd like to do, Brady, is I had just a few more things to mention about what we're doing today, if I may. As a point of clarification for the final consensus on day 2, we're going to take one final consensus on all the technical corrections and changes in sections before subpart G. So sections 30.80 all the way through, all the way through before subpart G. We'll then take a final consensus on each regulatory provision in the new subpart G, and that's going to be done separately. So I just wanted to make sure that everyone understood that the technical corrections are a little bit different. We will be grouping those together for one final consensus tomorrow. So Brady, if you don't have any additional comments, I can go right into the other changes in part 30 and ask the team to share those screens.
Yeah.
Thank you. All right. So in 34 CFR Part 30 debt collection in subpart A, we have made a correction to some outdated language in A2. We're going to refer the debt to the Government Accountability Office for collection. In 4B, we have made technical corrections to update to 31 CFR parts 900 through 904, as opposed to what was listed before was in subpart 4. Excuse me, it was in part 4. Additionally, we have added point 7, which is waive repayment of a debt under subpart G of this part. We have, of course, renumerated 8 and 9, paragraphs 8 and 9. We've also added a severability clause. Additionally, in Part C, which is 30.20, we have once again in A1 Romanet 2 updated the IRS tax refund to the Treasury Offset Program. And we've changed the word exist or exists to exist. In three Romanet 2, we've removed paragraph 4. We've proposed for deletion in paragraph 4 and did a minor grammatical update in Romanet 2. In 30.23, we have again changed B1 to just some minor changes, including the debtor's social security number from the reg text. In 30.25, we have another minor conforming edit change. 30.27C, we have updated the regulatory reference from 4 CFR 102.3 to 31 CFR 901.8. In 30.29, paragraph A3, we've again updated the regulatory text to 31 CFR 901.3. In paragraph 3, we have updated yet again, there's a pattern here, the regulatory text to reflect 31 CFR 901.3. And in 30.33, we have again changed the IRS tax refund to Treasury Offset Program. Subpart E, 3062A, we've updated the regulatory text and we've added or to the extent that waiver of repayment of these amounts is appropriate under 30.80, section 30.80. In B1, we've updated regulatory text changes again to 31 CFR Part 902. And then in D1, we've updated again 31 CFR 901.8. We've added a severability clause in 30.69. In subpart F, 30.70, we have changed from the secretary uses to the secretary may use in paragraph A1. Again, in C1, the secretary may use the standards in the FCCS. And in paragraph 2, we've added the words of this section after paragraph E. In paragraph E1, we have added the reference to the Health Education Assistant Loan Program authorized by Section 701-720 of the Public Health Service Act, 42 U.S. Code 292-292-0. And in 30.79, we've added another severability clause. And that brings us to where we'd like to stop and turn this over back to Brady.
All right. Thank you, Tammy. Richard.
Oh, I'm sorry, Brady. I do still have more comments. I'm sorry. I'm a little slow in the uptake today.
That's all right.
As you've seen, we've made small technical corrections to this section because most of these regulations have not been amended since the late 80s and many references are out of date. So even though these changes and corrections are technical, we will take consensus on the changes tomorrow. And while there was a suggestion for a number of changes to 30.70 around compromise, our focus is on waivers. So we're not going to take those substantive changes here, but we may discuss those ideas presented under the hardship discussion on day 2. All right, now back to you, Brady.
Thank you. Richard and Kira, I see your hand. Are these questions for the negotiating committee? Okay, great. Go ahead, Richard, please.
Good morning. Sorry, we jumped right into the text. I actually should have asked this question in the beginning when we were kind of setting the table for the day. So one of the questions I had, I know we spent a lot of time in the last 4 gatherings talking about hardship, and a lot of the proposals that were submitted were centered on the issues of hardship, but I noticed that they're absent in the agenda here. Can someone from the department clarify what the plan is for continuing discussion of those items and the hardship topic in general?
Yes, we plan to discuss that at the end of final consensus. We did mention that a little bit earlier, perhaps not as clearly as we should have. So thanks for bringing that up. But we will, at the end of final consensus on day 2, we will have time for a discussion and if time permits, a presentation.
So if I can understand correctly, the expectation is that the the negotiators will be taking up down votes on what's in the language here without knowing at all what the plan is for handling the hardship, which was, I think it represented a large portion of where our concerns were concentrated.
Yeah, we have not proposed regulatory text for the negotiating committee to review and provide consensus on. So the paragraph of hardship, we have, much like last session where we discussed it and we did not have proposed regulatory text, we did not bring forth proposed regulatory text this session either. So our hope is to, and we'll talk more about this tomorrow, but our hope is to engage in additional conversation with the negotiators and get additional information so that we can take that back and make additional decisions later.
I understand. If I can just share, as long as we're still having this exchange, that I understand that it's a big topic for us to tackle, but it's going to be hard to really get a clear sense of where I want to be on some of the items we're going to discuss in the next day and a half, not knowing where we're going to go with the hardship issue because that represents so many borrowers. So I understand that the agenda is laid out and it's not maybe it's not possible to change it, but I do think that it represents a problem in the decision-making process. So.
Thank you, Richard. Kieran, Jessica, I also see your hands. Are these, again, more questions or is it feedback for the department?
Feedback for the department.
If it's okay, is it okay to take a temperature check first and then solicit that feedback?
Wait.
Oops,
Sorry,
but
Karen, you go ahead.
I'm not speaking for you, just for myself.
Yeah.
Sorry, usually when we do this, like the department goes through the reg text and then we get to say stuff and then we take the temperature check, but you wanted the department to go through the reg test and then we do the temperature check and then we say things?
That's the plan, yes.
Okay.
Okay.
I mean, that's fine now. I think in the future that might be hard because I think the responses to what we have to say might depend on how we do the temperature check, but you could facilitate how you want to facilitate.
Jessica, what we're trying to do here is get a gauge right now today on where we are with the reg text and do a temperature check on that so that we can engage in discussion with you. Perhaps there are things that you bring to our attention that we need to take back to present tomorrow for further consideration and final consensus check. So this is the way that we've chosen to do this because we want to make sure that we capture important essence of things, and we may not be able to do that if we have to take those items back. So it's best if we discuss after we take we want to know, are we there? Are we not there? What do we need to do? And so this is the way that we've chosen to do that for this session.
Okay, sorry, I don't mean to belabor this. This is not important for the background, but I think it's important for the rest of the day. Okay. Tammy talks, we have the screen share, and then we do a temperature check, and then we get to say what we want. And then we do another temperature check, or then we're done and we just wait.
No, from a process perspective, the temperature checks are non-binding and relatively informal. It's really just the chance for the department to solicit feedback from folks that might have serious reservations about an eventual consensus check. All the official consensus votes are going to be held tomorrow after everyone's been given a chance in this process, in the more informal temperature check, to offer feedback to the negotiating committee on where they stand right now on proposed regulatory text.
Okay.
Just to jump on that procedural point really quickly, I think it would be helpful if there's the possibility of a subsequent temperature check, just to assess whether or not the department's responses ameliorate any of the concerns that were raised initially, and that will expedite how we move through things during the day and tomorrow potentially as well.
Understood. Gotcha. Okay. Tammy, did you want to walk back through subpart G or that initial walkthrough? You want to take the temperature check now?
We wanted to do, because we're going to take consensus on all of those changes tomorrow, we wanted to present this as one like 3070 and above, pre-subpart G collectively. So if we would just take the temperature check on 30 point, on everything pre-subpart G, and then we'll go from there after discussion. Thanks, Brady.
All right, thank you. So with that, again, we got a little practice this morning, but again, if folks actually want to use their physical thumbs rather than the react buttons on Zoom, where they stand on a temperature check, again, an informal check on where you are on everything preceding subpart G. A thumbs up would be like, love it, can live with it, serious reservations. I see at least 2 thumbs down. I see Kira and Ashley. Did I miss anyone? Okay, thank you. So what I'm going to ask Kira and Ashley to do now is feel free to come off of mute. Ashley, if you'd like to go first, if you want to share what your serious reservations are, and then critically, if there are amendments you'd make to the proposed changes that would at minimum move you to a sideways thumb.
Off mute here. Okay. I once again want to thank the department for the time and consideration. After 2 months of being involved in this committee, sitting here listening to hours upon hours of folks trying to define hardship and who is worthy of cancellation, I am disappointed and frustrated. This policy leaves a lot to be desired. The policy changes are in no way big enough, fast enough, bold enough to address the proportions of the catastrophic student crisis that we are dealing with. It feels like everything that has been said in the last 4 sessions has fallen on deaf ears. It really feels out of touch, and to be honest with you, there isn't any of the language defining a hardship. But there's something even more important that I want to remind everybody here. The Department of Education does not need new regulations in order to cancel the student debt. Under the new regulations, under the current regulations, it can order release people from the shackles of the student debt with the stroke of a pen. Over 30,000 people have filed demand letters directly with the Department of Education expressing their hardship and need for cancellation now. Every single piece of paper behind me represents one of those borrowers demanding that you use this authority to release them from this unjust debt. Does the department plan on using these demand letters? If so, when will people expect to hear from you? People cannot wait until 2025 or whenever the department decides to roll out these insufficient and vaguely defined policies. They certainly can't wait for the inevitable court fight to allow the policy to move forward. Heck, have any of the borrower defense applications that have been reviewed at this point outside of the several lawsuits against the Department of Education? It is extremely lucky that I am able to be at this table. Most ordinary borrowers can't take days off work to sit on hold for hours and hours when their servicers mess up their payment schedule, the amount they owe, or refuse to honor their save plan or lawsuit cancellation. Real people depend on their credit reports to function in this society. These loans are the cruel incompetence of the department, keeping them in poverty. Millions of families are unable to live the American dream that they were sold when they signed up for higher education. It doesn't have to be this way. Folks are burnt out and waiting and squeezed beyond their means. They're apathetic about voting on empty promises. It's actually pretty terrifying going into the next year's election cycle, knowing firsthand how done people are. All of my data requests and suggestions have been denied or ignored during this process. I'm here representing borrowers, not clients, not cash flow, not votes. Rather, real humans who have lives.
Jessica, 30 seconds.
With the yo-yo promise of fixing this mess. We are out of time. My question is to you, when will the Department of Education process this cancellation? When it's too late? Thank you for your time.
Thank you, Ashley. Kira, I know you also voted thumbs down. Would you like 2 minutes to speak? Please go ahead.
Great, thanks, Brady. So I would just like to note, I support the discretionary use of the federal claims collection standards in 3070. However, like Rich and like Ashley have noted, we don't have all of the proposals on the table right now. We're missing a significant portion in not having the regulatory text for what the department is considering doing with regarding hardship. But even if we had the hardship proposal, I would strongly encourage the department to take this opportunity to revise 3070 to create an enduring process for borrowers to compromise their debts. As we've seen time and time again, when the department has tried to provide targeted relief to borrowers, there are still borrowers who get left out. In addition, while 3070 is on the books, the department is not using its compromise authority either under 1082 or under the Debt Collection Improvement Act and federal claims collection standards to its fullest extent. This must change moving forward because we have to take bolder steps to make sure that distressed borrowers are not within the student loan portfolio and that debts are right sized to what borrowers can afford to repay. So for that reason, I cannot support these changes.
Thank you, Kira. As we move to the next section, I do just want to remind negotiators, I know we said it once before, but any proposed changes to these regulatory texts, we welcome the submission of those, especially the folks who currently are thumbs down on these. Anything else on this particular piece of the reg text, Tammy? Are you okay to move to 3080? I believe you're muted right now. There you go.
I am. It wouldn't come off. I think we're ready to move on. Thank you.
Okay, I'll turn it over to the department.
Right. So the reg text in paragraph section 30.80, I'd like to point out that we've separated each proposed waiver policy into its own section. We believe this makes it easier to view the distinct policies and assist with the process of temperature checks. We've made some edits in every section that we will discuss as we go through the individual sections. Let's start with section 3080. This is an overall lead-in section. We've not made any significant changes here from our last session, and this text still captures the same loan types. As a reminder, this waiver authority, excuse me. As a reminder, this waiver authority only applies to loans that are held by the federal government. It does not cover commercial Perkins, federal family education loan programs, or FFEL, or health education assistance loans, HEAL. There was a suggestion from a negotiator to strike the mention of direct loans. We do not think that is appropriate. The Secretary's authority under the Higher Education Act applies to direct loans. These are loans that the department owns and loans that the Secretary has been granted the authority to waive, modify, and release. We also wanted to mention that while there was a proposal to require an analysis of the effects of persons who never attended college, paid off their loans, and taxpayers, we do not think that adding such a requirement would be appropriate. The Secretary of Education is authorized and required to administer the federal student loan programs, which considers the participants and stakeholders of those programs. However, as part of the regulatory process, we're required to develop and include in the notice of proposed rulemaking and the final rule a regulatory impact analysis, which includes analyses of costs, benefits, and transfers. And from a regulatory standpoint, the spending on issuing a waiver that relieves borrowers of some of their obligation to repay would be considered a benefit to the borrower and a transfer from the federal government to borrowers. We believe that required analysis will appropriately address the issue of overall costs and benefits in a manner consistent with the analysis of other federal regulations. I'll turn it back over to Brady now to discuss 30.80.
All right, thank you, Tammy. We can unshare the text. Any questions for the department at this time? Otherwise, I'll move us to a temperature check. Yeah, Jessica.
Hi, Tammy. I just want to clarify something that I think I understood you to say, which is that 3080 and the subsequent provisions apply to all FFEL loans except for commercially held FFELs, and that the narrower FFEL provisions that are at the end here in the FFEL section apply only to commercially held FFEL loans. Is that the right relationship here?
I see her nodding, but I think
Yes, I can't find the mute button today. I'm so sorry. Yes, Jessica, you are exactly correct. Thank you. And I would mention that it's Ed held Perkins as well, so that we clarify it's not commercially held Perkins either.
All right, thank you. I do just want to note, I know I missed you during roll call, but I just want to welcome Jaleel Bishop on behalf of graduate student borrowers to the table, who's stepping in on behalf of that constituency group. So good morning, Jaleel. With that, I'll move us to a temperature check. Folks want to indicate how they feel about 3080 with their thumbs. Let's see. Most folks have voted. I see one thumb down. Jaleel, feel free to come off of mute and share your reservations with the department. And then, as always, if you have any proposed modifications or changes to the regulatory text.
So just clarification on process. We here will share reservations and then have the opportunity to send in amendments or alternative text.
Yeah, absolutely. And if you can do that as quickly as you can so we can disseminate it to the negotiators, that would be great. This is the temperature check is fairly informal, just to get a sense of where the committee is right now. And Cindy, feel free to.
Yeah, I mean, I think really echoing a lot of the points raised by Kira and Ashley around just the need to make sure we're providing relief that reflects the urgency and the burden of the student debt crisis. I think that we need to see some type of regulatory text here that's really addressing borrowers having some type of full cancellation or some type of significant decrease in the original amount that they borrow. So from my understanding, a lot of this is getting at borrowers' interests. It's tackling some of the issues that borrowers are experiencing around a growing interest balance, but I would like to see cancellation that reflects the mountains of research that shows just what that overall balance does for borrowers, which I think my proposed or amended text would be some type of regulatory text that actually is canceling the full debt for some of our borrowers who are low income, some of the borrowers who are carrying a disproportionate amount of debt. I think a lot of this could be tied into hardship regulatory text, which we don't have. And then my other big issue is around the 10 or 20,000 cutoff. So I think that I am not sure how we got to the 10 or 20,000. I haven't heard evidence yet from the department of why those two numbers were selected as cutoff. But I think that borrowers should be seeing relief where they see at the very least their overall original balance decrease, not just a decrease in the interest that accumulated over time. So those kind of be the two big points for me of why this text doesn't feel like it's where it needs to be.
Thank you. Cindy, I see your hand up.
Yeah, I just wanted to kind of touch on Jill's question. If you have a concept of an amended text or actual verbiage, feel free to put it in the chat. Or if you don't, get it to us as quickly as possible so the department can consider it for tomorrow's session. Okay. So I just wanted to reiterate those two things. You have the chance to put it in chat and or send it to us and we'll disseminate it.
Thank you, Cindy. Yeah, Tammy.
So I just want to make one comment to Jaleel's comments. You talked about why the 20,000. We believe this is an amount that provides meaningful relief to most low-income borrowers or borrowers on the SAVE plan.
And around that meaningful relief, how are you defining meaningful? What is that being based on a data set? Is it being based on, some type of range of evidence? Just trying to understand how meaningful is being defined here so that the 20,000 doesn't seem arbitrary.
So I would hope that we could go back to 30.80 because some of what you're talking about now is in 30.81 and 30.82. So if we could kind of just rewind just a little bit and finish up with 30.80, then I can go into some of the information there that may provide additional clarification for that.
Thank you. Tammy, anything else you want to solicit from the group on 3080, or are we okay to move, as you suggested, to 3081 and 82?
We're all set, Brady. Thank you.
All right, I'll turn it over to our screen sharers again.
In sections 30.81 and 30.82, we're proposing two separate policies here related to negative amortization. We will discuss two other policies that are separate and distinct on negative amortization in sections 30.89 and 30.90 tomorrow. In section 30.81, we are proposing to cancel up to $20,000 of the amount above what a borrower owed when they entered repayment. In other words, we would be waiving $20,000 up to $20,000 of accrued or capitalized interest. Borrowers would be eligible if they're on an IDR plan and have income at or below 225% of the federal poverty guideline, which is about $67,500 for a family of four for 2023. We know a borrower's income if they are on an IDR plan, so therefore we may not need the borrower to provide additional information in this case. Additionally, because we're including Ed held FEL, we have included a reference to the IBR plan for FEL. And as a reminder, this waiver does not apply to commercial FEL. In section 30.82, we're providing up to $20,000 in negative amortization relief for borrowers who are on the Saving on a Valuable Education or SAVE plan. A borrower who is on the SAVE plan and whose income is less than $125,000 as a single individual or $250,000 as a household may receive this waiver. Because we are addressing negative amortization going forward in the SAVE plan, we wanted to target this change toward borrowers on the SAVE plan instead of all IDR plans. One thing to note on this provision, we are not including requirements related to time and repayment. We discussed this during the last session and think we can use data on the balance owed at the end of a borrower's grace period for loans dispersed starting in 2005. This allows us to focus on negative amortization after entering repayment. We do not have data that would allow us to make that calculation for loans older than 2005, so for those loans, we focus on the amount dispersed. It is our hope that borrowers with older loans would have paid down their in-school interest by now. We received some suggestions from negotiators regarding forgiveness tied to the amount already repaid or eliminating any borrower eligibility requirements. Unfortunately, we're not able to take these suggestions. We considered suggestions regarding amounts paid. However, we are concerned about those being accurately captured. Next, our proposed text addresses having borrowers adjusted gross income or other income documentation that is acceptable to the Secretary. And finally, we note that a borrower cannot obtain a waiver under both of these sections. Their benefits would be the lesser of $20,000 or the amount by which their current balance exceeds what they originally borrowed. Brady, I'll turn it back over to you.
All right, thank you. Any clarifying questions for the department on 3081 or 82? Yeah, Jessica.
Sorry, this is just a minor drafting thing. I just note that some borrowers might have loans that fall into categories 1, 2, and 3, and I'm not sure as written that it necessarily would capture that, but I think I understand what you're intending.
Thank you, Jessica. Any other Yeah, please, Richard.
Yeah, I have concerns with a number of items in 3081. For one, I'd like to propose that we get rid of the use of the language says the lesser of, waive the lesser of 20,000 or the amount by.
Richard, very, very briefly, if this is a suggestion for the text, we might just wait for the temperature check.
Okay.
Because then we can just capture everyone's potential suggestions sort of at the same time. But this is if you want to clarify the department's current.
No, I understand the proposals. Okay. I'll wait for the temperature check.
Okay, thank you. Any other clarifying questions? Okay, great. Sorry about that. If folks want to indicate where they are right now with a vote of their thumbs. I see one, two. If folks do have their thumb down and want to share suggestions or what their reservations are, if you just want to raise your hand, because we had a number of thumbs down on that one, I want to make sure I don't miss anyone. And since I cut you off initially, Richard, I'll turn it over to you first. Sorry about that.
No problem. So that was one. I would like to propose that the department consider removing the language that says waive the lesser of the 20,000 or the amount by which the borrower's loans cumulatively, blah, blah, blah. That's one piece. I've shared concerns in all of our prior sessions about formulas that are tied to income, not necessarily working for all parts of the country equally. I feel like part B, I think it's B2 here, might kind of fall back into that trap a little bit, and I think it's important to try and address it. And finally, just, in general, I feel like the cancellation of anything that exceeds what the original balance was. I still think, I'm going to be honest, I think I used the phrase in one prior session about kind of righting the wrongs that had been done to people. If we have borrowers who've taken out, let's say, $80,000 in student loans, have been making payments for 20 years and still owe $70,000 in those student loans, this does absolutely nothing to, I think, if I'm understanding it correctly, to really correct that situation. So I'll be the first to admit I don't necessarily have alternate language that would fix that. I think I liked some of what I've heard in the past about applying payments that have gone towards interest towards reducing the actual original principal balance. I think that's the closest I've heard to anything that I think would really address that problem. So there's a number, it's a good start, but I think that there are a number of issues here that I'd like to see improved. So.
Thank you. Yeah, I'll turn it over to you.
Thank you. I was very disappointed to see the department add a cap to student relief here. I feel strongly that borrowers should have at least the amount that exceeds their original balance forgiven. And it sounds like the department's explanation here was technical and administrative, but that doesn't explain to me why the department can't draft the text as it was drafted before and give itself the discretion to determine the appropriate amount of relief. There's a distinction between the draft of the regulation and the way the department ultimately applies it. And it may well be the case that there are times that the department comes up with a number that they think is the appropriate number, and through whatever action they take to implement debt relief, they can explain that number and they can do it that way. But to deprive themselves of the discretion which is typical in these types of regulations, to make determinations that vary from this 20% or 20,000 or 10,000 seems short-sighted to me, and leaves me quite concerned that there are a large number of borrowers who will not be getting relief that they so sorely need and should be getting. And I really encourage the department to draft these regs in a fashion, again, this was a surprise coming out of the second session, these caps, to draft the regs in a way that give the department the discretion to be responsive when it is necessary for them to be responsive, and to make determinations that are appropriate given whatever circumstances they decide to use, or in whatever circumstances they decide to use their authority to forgive student debt. Thank you.
Thank you. Kira, I have your hand next.
Like Gail, I am also very disappointed to see this proposal. I will say amongst my legal aid colleagues, we routinely see people that have accrued more in $20,000 of outstanding debt beyond what they originally borrowed. This is especially true given the history of forbearance steering, folks who have been in low or $0 IDR plans where their balance has ballooned over time. And so I'm deeply concerned that this proposal will not provide those borrowers with appropriate relief. I would propose that the department could limit discharging the entire amount so that it is somewhat income targeted by targeting Pell recipients, by discharging the full amount that exceeds the original principal borrowed for Pell recipients, low-income borrowers, or individuals on the SAVE plan. I'm also concerned that not everyone will be eligible for the SAVE plan. So I would hope that the department would broaden this proposal broadly as well, because I do not think that the SAVE plan is going to capture enough people. And I will stop there.
Thank you. Jessica.
I agree with a lot of what Kira and Yael said, but I want to so take that, and then I want to make one additional point, which is I hope that I misunderstood what the department said at the beginning, but I think that many of us had proposed focusing here on a borrower's payments and payment history and how much potentially reallocating those payments so that they were to principal, not interest. And I thought I heard the department say that the department wouldn't have payment records for some or all borrowers as a reason not to consider those proposals. And I find that extremely concerning. And I think that, we've made this point over and over, but that a principle of this rulemaking should be if the department doesn't have records of what someone paid on their loans, it absolutely should not be collecting on them. And I think if there are any places, where the department thinks that it lacks accurate payment data, that in and of itself should be a basis for loan cancellation. And so I just like to make that point generally here, and I think there are some other places later it applies, but also specifically here, I think to the extent we don't know what the payment history is, we should be really making that in favor of the borrower.
Okay, thank you. And then Ashley. I believe you're muted right now.
I just wanted to follow up and kind of reiterate what Jessica said. I'd like some clarification about the concerns about not having accurate info and uncertainty around payment amounts. I also agree that the cap is really just unjust. There are so many borrowers that I know that I deal with on a daily basis that have way more than $20,000 in just interest alone. I myself took out my loans in 2002. A lot of my classmates are still waiting for their borrower defense applications to go through, and all from those time periods. So it's a little concerning to me that one, there's a cap, and two, that the department does not have the records in order to adequately manage these loans. Can we get some clarification on that?
Not seeing an immediate response. I do want to turn it back over to the committee if anyone else wants to share a serious reservation they have or any new proposed amendments to 3081 or 82. Yeah, Kira.
I would just like to make the additional point that in the earlier regulations that exist that discuss the waiver of interest and collections, it appears that the provision that applies to non-student loan debts is actually more generous than the provision that's provided here. And like Yael and Jessica mentioned, I think it makes more sense for the department to provide itself with discretionary authority to meet the moment. If it becomes obvious that there have been mistakes in policies that have resulted in ballooning balances and the accrual of interest, as the department has corrected, which we applaud moving forward, or if it becomes obvious that there's servicing misconduct that has resulted in borrowers having ballooning balances due to ballooning interest as well.
Thank you. Tammy, any other questions to pose on 3081 or 82 to solicit additional feedback, or are we okay to move to 3083?
Actually, Brady, we have had a minor adjustment in the schedule. I don't have anything to add on 3081 or 3082, but we are moving 3083 to after lunch today. So we would actually draw your attention to 30.84 and 30.85 next when we're ready.
I'm ready if the department is.
We're ready.
All right.
So we're going to focus our attention on 30.84 and 30.85. While these are similar ideas we had in the last session, they're now in individual sections. We did not make any significant changes to what is now section 30.84. This still captures the various repayment plans that provide forgiveness after a certain amount of time in repayment. Again, you'll see here a reference to the FFEL IBR plan, which is included because of the Ed-Peld FFEL. In section 30.85, we simplified this language. We received some language from the negotiators who proposed using a catch-all instead of listing every type of forgiveness opportunity. There are various targeted loan discharge, cancellation, and forgiveness options in the HEA, in the Higher Education Act, and many of those are not considered programs. We think using the word opportunity is the appropriate way to refer to these. We also note that this approach would address the proposal regarding false certification discharges that was provided by a negotiator as well. And lastly, we received some suggestions from negotiators to include issues such as servicing errors that made borrowers ineligible for a benefit or program. We do not feel that would be workable. The standard of what would rise to that level is unclear. And as you can see in our announcements regarding various fixes to IDR and the resumption of payments due in October, the department steps in when we identify problems and we resolve these problems, which is something we do all the time. This is an area where we had some other suggestions from negotiators about public service loan forgiveness. As we discussed in other sessions, we are not amending the rules around PSLF. So changes adjusting the definition of public service or addressing items related to the limited PSLF waiver do not work here. Brady?
Thank you, Tammy. We can bring down the text. Thank you. Any clarifying questions for the department on 3084? Yeah, Jessica. Oh, wait, I saw your hand. There you go.
Sorry, I was just going to ask if we could separate them. That was all.
Right, absolutely. Yeah, sure. Not seeing any immediate questions arise on 3084. Would the voting members of the committee indicate where they stand right now on 3084, the language that was just shared? Still waiting for a few folks to indicate where they are. I don't see any thumbs down. Apologies if I'm missing anyone. I think we are, we have a few sideways thumbs, but I don't see any thumbs down. I will turn it back over to the committee. Any additional feedback or consideration for the committee on 3084? Okay. Tammy, anything additional for their consideration on this part of the reg? All right, then I think I'll turn it back over to our screen shares for 3085.
Brady, I think we did both of them. So I think if we could just, unless I'm missing something, I don't think that I am. No, we did both of them together.
Okay. Gotcha.
Yep. Thank you.
Richard, I see your hand.
Thank you. Yes, I have a couple of questions on 3085. First one, I was wondering if someone could speak to the process for identifying those who are eligible but haven't applied here. Are there, is there progress being made towards automation? I know that's one of the things that we talked about in prior sessions, but we, just would like to see how we do a better job of actually capturing these eligible borrowers. That's one question there. Second question, I was wondering, I understand we're not looking to amend the PSLF language necessarily, but I'm curious, I know we are expecting updates to it, and I'm wondering if the department has any information on when those might actually be coming.
So if we can identify them with administrative data, then we could catch them. So we will be doing everything that we can on the administrative side of this to look at the data and find those borrowers.
And the updated language, I believe there were a number of items in those regs that were supposed to be clarified, that maybe they would answer some of the other proposals that have come in.
So I do want to mention your PSLF question though, because I think that we do plan to issue additional information on PSLF in a later regulation. So we're not really, and that focuses on eligible employer. And so that's not part of these negotiations. So we won't really go into PSLF here, but do expect to hear from the department at some time in the future on within a separate regulation about the PSLF eligible employer issue.
So I wasn't asking that we dive into the language itself here, but I was asking if you had an ETA on when we can expect some of that language.
I don't.
You do not.
I don't have an ETA, but we are working on it.
Thank you.
Mhm.
Any other questions before we ask for a temperature check on 3085? All right, not seeing anything. If folks want to indicate where they are on the proposed text for 3085 with a show of thumbs. Don't see any thumbs up. Again, if I'm mistaken, feel free to correct me. Great, thank you. While no one did indicate serious reservations, is there any other questions or comments for the committee?
Hold on, I thought Kira had a thumbs.
Oh, did I miss that? I'm sorry, Kira, go ahead.
Thanks, Brady. So I will say I am all in support of trying to automate relief for as many borrowers as possible. However, under this section, I am really concerned about the possibility that borrowers will be treated differently if this authority is used versus the authority provided by the relief program themselves. Some of these relief programs provide supplemental authority in the form of refunds, the deletion of adverse credit history, etc. This additional relief is especially important to borrowers who have had their loans go into default and have lost potentially thousands of dollars to involuntary collections. This regulatory language does not ensure that those borrowers would receive that supplemental relief. In addition, while right now there is a law that excludes loan cancellation from federal income and taxability, that provision is set to expire. And some of these relief programs have their own independent statutory language excluding them from being counted as taxable income. And so there too, I'm concerned that under this provision, if this authority is used as opposed to the relief program, those borrowers may face tax consequences depending on what happens to that statute. So there again, while I support automation and I was thrilled to see the group relief provisions in these relief programs themselves, I'm concerned about what will happen to these borrowers if this authority is used.
Thank you, Kira. And as always, any proposed amendments from the committee, we still do have time to hear those out if folks want to submit anything in the chat or via email. Tammy, anything else you'd want to solicit from the group on 3085? No?
Nope, not at this time, Brady. Thank you.
All right, I think that there's been a request for a short break. So if negotiators are okay to hit pause right here and just take a quick 15-minute break or so, and we'll resume. Let's see, I have 11:07, let's say 11:25 to be back on camera. Okay, see you in a bit. All right, welcome back, everyone. I think I want to pick us up before we head to lunch, just if there's any additional feedback for the negotiating committee or the department on any of the proposed regulatory texts that we've discussed thus far today. I know there's some more to come, but anything that folks want to add, particularly questions for additional consideration of the committee before we move on. Yeah, Julia, you're muted right now, but go ahead.
Thank you. My raise hand function wasn't working. I want to come back to some of the earlier regulatory texts, 30.81, 82, and so forth, because I think that we are in a moment where I first have to question kind of the good faith approach of this negotiating process. So we have had months of conversation, both here at the table, but also negotiators, the department preparing for these sessions. We were presented with hardship categories with different topics to discuss. And I think it's really hard to engage in what I would consider a good faith conversation, let alone a negotiation, without having some indication of where we're going on the hardship text. I think in addition to that, to introduce the 10,000, 20,000 caps at this stage in the negotiation, again, I still haven't heard a rationale explanation of why those were introduced and why they're justified. Again, just makes me wonder about the good faith effort, negotiation, research, proposals, and expertise that went into really trying to create relief proposals for borrowers. So I really encourage my other facilitators on the negotiators on the call to really advocate and speak up if you also are sharing these sentiments and feelings that something about this negotiation process has taken a turn where we are not seeing the conversation, the buildup, and what we have been focusing on reflected in this moment in time. And I also would like to remind the department that there are real borrowers on the other side of this regulatory text. That just yesterday I sat in Philadelphia with 40 teachers in the Philadelphia School District where they talked about their student loan debt. They talked about the hardship of carrying balances that are hindering not just their ability to save for retirement or buy a house, but hindering their ability to have a good sense of self as they're moving through their life, to hindering their ability not to be stressed, to feel hopeful, to navigate a lot of the work and things that they are trying to do in our public school district, not just as teachers, but as human beings who shouldn't be under burdensome student debt. And that is one group on top of the many groups that we have talked about so far in these sessions. And I just don't see that reflected here in this regulatory text. And I'm just really more encouraging the other negotiators to speak up and speak loudly about your groups if they're not reflected, because I think there's some real dangerous restraints that I see being proposed right now in the regulatory text that don't offer us the bold and justice-driven relief that we need.
Thank you, Jaleel. Yael.
Thank you. I just wanted to flag that one of the requests that I and other negotiators made in recommendations following the regulatory text that was proposed at the second table and also in discussions since the first table is that these regulations more clearly create avenues for the department to provide relief to people who have been deprived of relief in other forms or generally have been subjected to service or misconduct. I don't think that the proposals that the department has put forward do enough to address both the historic harms that have befallen borrowers due to widespread and pervasive service or misconduct, of which we have seen considerable evidence, and truly it's irrefutable that that's the case. And in addition to that, I don't think the department has done enough to create avenues for itself to address the types of service or problems that have occurred historically if they occur in the future, and there's no reason to think that they couldn't. I really do want to emphasize that the department could be doing more on this point, and also that it would be beneficial for the department, since it's going through this rulemaking process now, to make sure that it's really creating tools that it can use, right? It's discretionary, it's not obligated to, but that it can use in the future when unforeseen problems arise, so that it doesn't find itself back in the position of needing to go through another regulatory process to try and respond to problems that are both predictable, and even if they're not predictable, could be addressed through the creation of discretionary tools that are broader than what the department has put on the table. So, as we go into the last, day and a half of the session, I really do hope that the department can consider ways to expand the regulations that were proposed. And I encourage the department to take a look again at the regulatory text that we proposed. Thank you.
Thank you. Richard.
I think I'm going to echo a lot of what you're hearing right now. That really, as I kind of took a step back over the last few minutes while we were on break to process where we are and where we haven't actually moved, really concerned by the number of constraints that are still in place. In not addressing servicer issues, in the absence of hardship language, and in some of the ceilings that have been placed on 81 and 82. Honestly, I feel like in good conscience, I can't support where we are on 3081, 3082 without hardship language, or hardship language without 3081, 3082. I think that those three pieces and adding the servicer misconduct, I feel like captures so much of the hardship, so much of the struggle that's out there that we've been talking about. And I don't see how we move forward without some of those pieces getting addressed.
Thank you. From the department, and anything else you'd want to solicit from the group?
Not at this time, but if there are no additional, after there's no additional discussion, I'll have something to say.
Okay. Sherry, please go ahead.
I want to echo the comments that have been made here. I voted neutral on 3081 and 3082 because I have real concerns and question also, is the department really negotiating in good faith? Has this committee and the work that they've done and the discussions we had any meaning at all? I too find it difficult to discuss anything's really going forward without discussing hardship. I'm concerned about the cutoffs. I'm concerned that some of the dates that the department has chosen for what loans they'll look at and when will fail to meet the needs of my constituency, which is 4-year borrowers, especially those with older loans. And I'm also concerned about the $20,000 cap and it not really doing enough to address the amortized interest and the capitalization of interest, and that $10,000 and $20,000 isn't going to provide the relief that my constituency really needs. I'm also concerned that with the offsets and being able to, garnish folks' Social Security checks and their income taxes refunds, that basically all the language that I've read is not going to help people. It's not going to, it's pushing people further into poverty, especially those in the low income group, low middle class, working class folks, and that the work that this committee put into this, both in our discussions in the last 4 meetings and in our other work with each other, that all the proposals and the work and the research that we did is being ignored.
Thank you, Sherry. John.
Yeah, I just want to reiterate that for a community of students with disabilities, talking about hardship is incredibly important. And in fact, a lot of, I think, my and some of our other negotiators' concerns about some of the, and I agree, unnecessary narrowness of the proposals put forward could in part or significantly be assuaged if we knew what hardship says, but we don't. And that's a real problem because at the back end, if we don't know to what extent people, the department is considering hardship as another, and I want to use this advice as catch-all for all sorts of things that should get caught by these narrow proposals but don't get caught, that might well change certainly my attitude towards some of these more narrow approaches. And for us to sort of not have any sense of what hardship is going to look like at the back end makes it really difficult to look at these more narrow proposals in isolation without knowing if some of the problems that we've identified could get fixed during hardship, such that we wouldn't necessarily want to vote them down. But not having any clue about what the department's going to do over hardship leaves us, we're all screaming into the void here. And I think you've heard pretty much from everybody that given all the questions you asked us about hardship, the evidence that and the proposals we put out to talk about hardship, and then to have it be, oh, we're going to talk about that later. I think that's problematic for many of us at the table.
John, Kira.
I'd just like to reiterate Yael's comment that it was disappointing that we didn't see language that would provide the department with discretion to respond and provide relief in light of servicing misconduct. In addition, like the other negotiators have commented, while I understand that much may be captured in the department's hardship proposal, I was disappointed to see that there isn't a discrete proposal intended to target borrowers in default. The data that the department shared shows that nearly half of borrowers in default have been in default for 7 years or more. That is 7 years where they could be subject to wage garnishment, losing their tax refund, which they may use to pay for medications, to pay for housing, to fix their car, and 7 years where they may be losing a portion of their other federal benefits like Social Security income, et cetera. The department has data, at least as to the most distressed borrowers. And so I'm disappointed that there isn't a more discrete proposal targeted towards those borrowers. In addition, when we do discuss hardship, I would hope that a borrower's default status on their loans would broadly capture more people in default. But at a bare minimum, I am disappointed that we don't see a discrete proposal for defaulted borrowers in particular, and extremely distressed borrowers in particular as well.
Thank you, Kira. Wisdom.
Yeah, just wanted to agree with my colleagues just around the lack of transparency in terms of our discussion around hardship. I think for particularly the constituency that I represent, civil rights organizations as well as young borrowers, many of the things that have been proposed so far does not really speak to what we have shared in the sessions prior that allow a broader, expansive view of how debt may be canceled or waived, as we've talked about in these sessions. I think it's important for us to really understand how this will have implications, not just in the upcoming 2024 year, but for years to come, particularly thinking about students who are currently in college, thinking about different ways in which we are looking at hardship, understanding that we have talked and not really discussed the understanding of financial hardship, educational hardship, social hardship, and how that plays a role within what has been proposed here. I think that if we are going to really have a discussion about hardship, I would propose and I would ask if there's an opportunity for us to change the agenda for us to have that conversation earlier rather than later.
Thank you, Wisdom. To the question on the agenda, I think we're going to provide an update on the proposed agenda after lunch. So I think more to come on that. But I do want to turn it over to Tammy because I know you'd mentioned that you had some comments.
Yes, I would like for us to call a caucus with Kira, please. The department and Kira. And then I think Brady make that a 15-minute caucus, then we can come back in, wrap up, and then break for lunch.
Okay, that sounds good. So just as a reminder for the caucus, they're not live streamed. And any negotiator, while there's one caucus going on, can always call a second if they want to speak to some folks as well. So we can go off live and I can make that move. All right, welcome back, everyone. Thank you for your patience during that caucus period. We are going to break for lunch now for the next hour and 5 minutes, and we're going to kick back off at 1 p.m. to resume discussion on the proposed regulatory text. So with that, we will see you in a little over an hour, and I believe we can go off live.